Hey y'all, what is going on? What is going on? It's your girl, Melba Pearson, Melba for Miami, Melba for Justice, also known as the resident legal diva. And it is time for another Mondays with Melba. So we're taking on a tough topic this week, the topic of the death penalty. And in Florida, we had a massive change in the way of a piece of legislation that got passed and signed by the governor that takes away the requirement in death penalty cases for the jurors to be unanimous in their finding of death. Before, it was all 12 jurors had to come to the same conclusion that death is appropriate. Now it's a matter of 8-4. So 8 people in favor of death is enough to be able to implement the death penalty in Florida. This is huge. So I'm bringing on somebody amazing who y'all have met before when she was actually running for state attorney of Pinellas County a couple of years back. Allison Miller, who is a defense attorney, has tried these types of cases and can really kind of break this down for us. So first off, Allison, thank you so much for joining us on Mondays with Melba.
Thank you for having me.
So let's talk about this. So first off, can you share a little bit about your background and your work and what kind of brought you to being on the defense side of death penalty cases, especially seeing that you also ran for state attorney, which is the other side people
right.
would.
Well, it's I'm not sure that's an easy question to answer, but I was a victim of violent crime. I was held at gunpoint. I walked into a robbery in progress when I was 14, and then I was a victim of sexual violence in college and kind of ended up in law school. I don't know. I always thought I was going to med school and failed organic chemistry and was like, well, now what am I going to do? Law school seems easier, which is not the case. Tremendous respect for those in the medical profession. So I ended up in law school sort of just by happenstance, but I do think the universe or God or whomever works in mysterious ways. And there was a professor that very much motivated me, Dan Markell, who's actually since been murdered, to want to go into criminal law. I am Catholic. I am somebody who personally believes in the dignity of all human life. I also think I get to make that decision for myself and myself alone. But working in criminal defense, I just sort of gravitated towards wanting to defend people facing the ultimate punishment. I know that seems a little bit strange. I was a public defender for about 15 years before I resigned to run. And we have like a weird promotional system. Like the longer you've been doing it, you defend people charged with more serious crimes. So you start out, defending people charged with misdemeanors and then kind of rise up the ranks. And I always just knew that I wanted to be someone who defended people facing capital punishment. And I'm someone that I think has the ability, and it's not always easy, to see the humanity in everyone. I have the ability to empathize with people, even those who have done conceivably the worst of the worst crimes and atrocities against humanity. And so, even within the criminal law profession, not everybody is meant to handle death penalty work. And so I think it's something that because I can, I should, and I think I do a fairly good job of it. At this point, I have defended just about 20 cases in trial, either as counsel of record or I'm often retained as an expert in jury selection. And I've handled probably another 40, 50 cases. I'm in the midst of a trial and it is killing my throat. But yeah, so we say in our profession that if we're in trial, we've already lost because our client's life hangs in the balance. And so the majority of the cases where the state of Florida seeks the death penalty, we are able to resolve with either a negotiated plea or a waiver of the death penalty where the state agrees to no longer seek it. So I've tried about 20 cases and handled or been a part of maybe another 40, 50 cases that we were able to resolve short of a capital trial.
So, I mean, that definitely, I think, gives a lot of background to folks, right? Because again, people see snippets on television or in the news and don't really know all that goes into a death penalty case. So, me having done it on the other side in terms of being a prosecutor, and having my own personal feelings about the death penalty as well, I always chose to seek, life without parole for a number of reasons. But what are some of the things that folks maybe don't really realize when it comes to the death penalty and the process, right? I mean, one big one for me, I'm definitely curious to hear what you have to say on that, is people think that somehow, okay, you get a verdict of death and that's the end of it, right? They don't understand that this is 20 years, 30 years of appeals that go on, and that oftentimes people die from natural causes, whether it be, old age or disease or whatever, before the sentence even gets carried out. But what are some of the things that stand out to you?
Right. I mean, that's definitely one of them. And it's, being somebody who's considered an expert in jury selection, right? When I'm speaking to people in jury selection, sometimes folks say the wildest things. And, one of the fundamentals of how we pick jurors is I'm not trying to change anybody's mind. I'm just trying to figure out how they truly feel, right? It's like, the death penalty is one of those topics like abortion or gun control. We're not going to have a 15, 20-minute conversation and all of a sudden people are going to feel differently about it. We're talking about deeply held beliefs. But sometimes people say things that I'm just like, that's not right. And one of the things that comes up most frequently is the cost, that people don't want to pay, or their tax dollars to go towards paying for incarcerating somebody for the rest of his life when he could just be executed. And the cost of seeking the death penalty is tens of millions to hundreds of thousands. The average cost of incarcerating a person in general population is just around 100,000 annually in the Florida Department of Corrections. The last data I saw, if the state is seeking the death penalty from pretrial through execution, is about 50 million per inmate. And so the cost of executing someone so grossly exceeds, right, the cost of incarcerating someone for the rest of his or her life. And you're right, part of that is due to the appellate process, which again, a lot of people say to me, well, we need to speed this up. And, if we're going to have a death penalty, perhaps it should be something that happens more quickly. But the reason why we have all of these appellate processes and procedures in place is because we get it wrong often. In fact, Florida leads the country in wrongful convictions. We exonerate more people from death row than any other state in this country. The national average is 1 in 9. In Florida, it's 1 in 3. So for every 3 people we sentence to die, 1 person is exonerated, which means determined to be factually innocent, not like a legal technicality, didn't do it. And so even proponents of the death penalty, I think, would agree we should be executing the actually guilty. And so we have all of these appellate processes and procedures in place, and still Florida gets it wrong. And you have to think, for every person that's been exonerated, how many have been executed or died on death row before that could happen? And a lot of my clients are being housed on Florida's death row. They've been granted relief of some sort, and so they're pending resentencing or pending a new trial, but continue to be held at Union Correctional Institution, where our death row is. And you speak the truth. Every time I go to death row, I am struck by, it's a group of really old men. Some of those guys, one of my clients was sentenced to die when he was 19 years old. He's now 50. He's been on Florida's death row for 31 years. There is a gentleman named Jacob Dugan who's being retried in Jacksonville. He's been on death row since 1974. So nearly 50 years later, he is being retried. He is 76 years old, with the average time that someone spends on death row prior to execution, if he were to be sentenced to die tomorrow, which is unlikely because he's not even set for trial, or he may be set for trial, but it's not tomorrow. He'd be 90 before he's ever eligible for execution, and life expectancy on death row is just not 90 years old. So, I mean, it is a horribly broken system that we've made even more broken with the passage of this new law.
So let's dive a little bit into the whole concept of unanimous juries, right? So, just about every other crime on the books, you got to have a unanimous jury, right? So everybody has to say, yes, absolutely, you're guilty, or no, you're not guilty for whatever reason. You can have different reasons as to why one person thinks you're not guilty versus another juror thinks you're not guilty. But again, they all have to agree on the final outcome. Why is it problematic to move away from unanimous juries? Is there a historical reason why this is important?
Yes, there is, Melba. Thank you for asking. No, I don't think. Oftentimes, when jurors come in, right, and they find out that they're potentially being selected for a capital case, right, you could sort of see their eyes get wide because no one contemplates actually sitting on a capital case, and so the mechanisms by which the death penalty is imposed, I don't think most people are familiar with, right? And so the only crime that's constitutionally punishable by death right now is first-degree murder. Our legislature has just passed a law to make capital sexual battery a capital crime, despite the fact that there is decisional law from the United States Supreme Court that says that's unconstitutional. But for the most part, it's murder one. In Florida, that is the intentional premeditated killing of an innocent victim. The defendant thought about it, meant to do it, and did it. Or it's felony murder, where the defendant was committing some sort of awful crime, arson, robbery, burglary, rape, aggravated child abuse. And even though the intention wasn't for the victim to die, the victim did die. And both of those are punishable by life in prison without the possibility of parole or death penalty. Those are the only two options. But in a death penalty trial, the first part of the trial is that like normal trial that most people think of, where the jury has to unanimously decide if the state has proven the defendant guilty beyond a reasonable doubt of murder in the first degree. And so that's what's wild is now this second part, it's almost two trials within one trial. The first part we call the guilt innocence phase, or the first phase. The second phase is the penalty phase, where the jury renders a verdict as to whether the punishment should be life without the possibility of parole or the death penalty. And so I can't conceive of a logistic or a practical reason why it would be easier to sentence a man to die than to convict him of a crime. And the underpinnings, right? So the United States Supreme Court decided a case called Ramos v. Louisiana in 2020, which is significant because the Supreme Court had largely the same partisan makeup that it does now. The only change is Justice Ketanji Brown Jackson, who is perceived to be a liberal justice, who replaced a liberal justice. But so largely the partisan makeup was the same. And Ramos, the opinion was authored by Justice Gorsuch, who is also perceived to be a very conservative justice. And the Supreme Court found that a law in Louisiana was unconstitutional because for non-capital crimes, Louisiana only required 10 of 12 jurors to render a verdict for a conviction. And it wasn't even a secret. When Louisiana enacted that law, oftentimes juries were primarily white, with at most 1 to 2 Black or people of color jurors on the jury. And so Louisiana passed a law requiring only 10 of the 12 jurors to be required for conviction in non-capital cases to essentially silence their Black or brown jurors' voices. And Neil Gorsuch, in a well-authored opinion, said, this is unconstitutional under the Sixth Amendment. And he straight out called out Louisiana for being a bunch of racists in the inaction of this law and trying to stand by it. And those same problems exist with what Florida is trying to do. Our juries are primarily white in capital cases. In order to serve as a capital juror, you have to be able to give meaningful consideration to both possible punishments, life without the possibility of parole or the death penalty. So anyone who says, I could not impose death under any circumstance, no matter how aggravated the crime, cannot serve. So fundamentally, everyone who is on the jury says, sitting in a room with the defendant, I could kill that person under the right circumstances. And so especially in our more conservative jurisdictions, kind of central north, our juries are almost all white. And oftentimes we only have 1 or 2 people of color. If the juries are almost all white period. There are certain circumstances where we have one or two people of color. And so now the legislature and the governor have made it possible for somebody to be sentenced to die with only 8 of those 12 jurors voting in favor of the death penalty. And the same problems exist that existed when Ramos v. Louisiana was decided. We are silencing our black and brown jurors' voices by passing legislation such as this.
And how do we end up with a situation where the jury's all white in 2023?
Well, there's a lot of reasons for that. One, this could be a longer conversation than we anticipated, right? You are not required to be paid for your jury service. Your employer cannot fire you, but they do not have to pay you. And so some of these more high profile cases, like I defended Markeith Lloyd in Orlando, and we lost the vast majority of our jurors when we said this trial is going to last a month, maybe 2 months. Who here could essentially leave their job for 2 months? Right. And so I was very struck, and it wasn't like the court was doing anything wrong. If a juror demonstrates an extreme financial hardship, they should be excused. Of course, we don't want people to end up homeless, not able to pay their bills to serve on juries. But I kept saying over and over again, Mr. Lloyd, as a Black man, is entitled to a jury of his peers. And I'm struck by the fact that the people we are losing because they cannot afford to be here are predominantly people of color. Mm-hmm. And even when the defendant is white, all of the research suggests that having a jury with diversity in perspectives and backgrounds, in ethnicity and gender, etc., leads to more robust conversations. And so, we could get into a larger conversation about systemic racism and why we have socioeconomic classes as they do.
That part.
But yeah, and most of the trials that I have been a part of, I can't help but also notice that the prosecutors seem to intentionally strike Black jurors. And I think there's a belief that Black jurors are going to be necessarily skeptical of law enforcement or inclined to either acquittal or to a life sentence. And I don't think that's true. I accept people tell me, right? Right? Like I accept people for what they say. But yeah, I'm in the midst of a capital trial in Volusia County, and of the first 5 or 6 peremptory strikes the state used, 5 were Black jurors. So, and we are entitled under several cases to request what are called race neutral reasons for the exclusion. But, it's not that hard to come up with something. But yeah,
it could be anything that, the jurors seemed disengaged when I was talking about this particular issue, or they mentioned a negative interaction with law enforcement. And because the, police officers are going to be featured heavily in the prosecution's case, this person may not be a good fit. I mean, there are a million reasons you can come up with that are race neutral on its face, but still have the end result of leaving an all-white jury or a less diverse jury. So.
Well, and jury pools are also coming from people with driver's license. And on top of that, we now know, right, that people are eligible to be reenfranchised as convicted felons. But I have to tell you, I mean, when I was campaigning for state attorney, one of the things that I want to work on very much as a side project is I would meet people who had felony convictions and were totally eligible to be reenfranchised, but were terrified because of what the governor did, or didn't know that their felony conviction was not an excludable offense for reenfranchisement. And so I very much want to work on, helping people, let's look up your, unless it's murder or sex crimes, for the
Yep.
most part, I'm overly generalizing, but for the most part, you're eligible to get your rights restored. And I think voting, serving on jury duty, as much as it's a pain in the butt, it's an important part of being, a member of our society. And so I really want to work on helping people in impacted communities to say, listen, let's look through all your felony convictions. Let's see what you owe. There have been very generous people from the clerk's office, from, different agencies that are willing to participate to try to help get voters re-enfranchised.
Yeah, absolutely. Because when we say reenfranchise, that's the ability to have some of your rights back, right? So just because when you're convicted of a crime, you lose certain rights, but you can get them reinstated. Again, depending on your state and your location, the process may differ. But in Florida, generally, once you've finished your sentence and if you've completed all your terms, so you've paid off your fines, any fees, any restitution to the victim or anything like that, depending on the charge, you're able to get certain rights back. So that's definitely another conversation that we need to have to kind of remind people, that there is a pathway forward to be able to be a full citizen in the community again, but you may have to take a few steps to get there, and it's super important. So, but with that being said, now we have non-unanimous juries. Basically it was a direct result of the events of Marjorie Stoneman Douglas, otherwise known as the Parkland shooting, because of the fact that the shooter, Nicholas Cruz, he admitted his guilt. And the only issue was the second part, as you were talking about, the first part being guilt or innocence, the second part being penalty. The only debate was whether or not it should be life or death. And the jury came back 9-3. So basically, they were split on whether or not life or death was appropriate. And since all 12 did not agree to death, Nicholas Cruz was sentenced to life in prison. And the governor used that as an example of the system being, quote unquote, broken, which, again, juries deliberate, they look at the evidence, they make a decision. But be that as it may, what's the path forward? Like what is going to happen next as a result of, this law went into effect pretty much immediately, right? I don't think it waited till July 1st.
Yeah. And I just wanted to point out, Florida still had more new death sentences than any other state in the country last year. Just one of them was not Nicholas Cruz. And I did work on his case as a jury consultant. And so I do have some familiarity with the case. And in the process, the jurors go through in deciding whether to impose a death sentence or not. The jury didn't even get to the last step. They actually stopped at step 4, which was, does the aggravation outweigh the mitigation, right? So the steps are, has the state proven an aggravating factor unanimously beyond a reasonable doubt? Killing multiple people is an aggravating factor. Many aggravating factors existed in that case. Step 2 is the aggravation sufficient to warrant the death penalty? Step 3 is, has the defense established mitigation? Step 4 is, does aggravation outweigh mitigation? And the final step, even if all of the answers to all of those other questions are yes, is death the appropriate punishment? Because a juror is always empowered to exercise mercy. But in Mr. Cruz's case, 3 jurors found that the aggravation did not, despite how extreme it was, did not outweigh the mitigation in his case, given his extensive history of mental illness and brain damage. So the path forward, elect different representatives. I think, there was a vocal outcry. I mean, there's so many things that happen this legislative session and continue to happen, right? That in my world, this was devastating. I am in the middle of a capital trial, and the law became effective April 20th when the governor signed the law. And now the state is moving to apply a law that became effective in the middle of our trial. And so it has been devastating. I know the people that I represent, not all of them, we've discussed, a lot of them are innocent, but many of them have done horrific things. And I'm never trying to excuse, justify, or defend their actions. But they are people. They are almost all badly broken, damaged, mentally ill, brain damaged, substance abused, some combination of the above people. And it is really horrifying to see. And so we did have, an outpouring of people contacting their legislators to say, this isn't what we want. And I think we've seen a legislature here that's willing to do the governor's bidding, even when it doesn't represent the interest of their constituents. I mean, we passed a 6-week abortion ban, which I think most people disfavor. And somewhat ironically, despite the fact that not everyone, but a large majority of people seem disappointed with the fact that Nicholas Cruz received a life verdict, we're now walking back some of the legislation that we passed in the wake of the murders at Marjorie Stoneman Douglas. We raised the age to buy long barrel rifles from 18 to 21 after MSD happened. And this legislative session, we've walked that back. So we have a legislature that I think has clearly demonstrated that they don't have any interest in representing the interest of their constituents, but are willing rather to help the ambitions of our governor and his efforts to become president. And so, we talk a lot about presidential elections. We talk a lot about Senate and Congress, and I certainly am not minimizing those roles, but we are day in and day out most definitely more affected at the local level by who we're electing to our state house and our state senate. And so if I could say anything, our state house, those representatives are up for re-election every 2 years. Mm-hmm. Find out how your reps voted on this. Right. I mean, that's what, I'm incredibly frustrated because I believe this is unconstitutional, but they also, again, as I mentioned earlier, passed a law that made sexual battery, again, a capital crime punishable by the possibility of the death penalty. And I'm not saying that I'm not horrified by sexual battery against children, but there is a case, Kennedy v. Louisiana, from the Supreme Court of the United States that says it's unconstitutional to punish that crime with capital punishment. And the governor has openly said that he passed that knowing there's law, jurisprudence that says that's unconstitutional, and he's just hoping the Supreme Court won't decide that issue the same way. And I don't think we should have lawmakers, especially those who are lawyers and members of the Florida bar, knowingly passing unconstitutional law. And I think there should be consequences, certainly with their legal license, for doing so.
Absolutely. Absolutely. I mean, because at the end of the day, you think about what that sets Florida up for, right? That means our tax dollars will have to go towards appeals and then cases that are going to go all the way up to the U.S. Supreme Court, which means a case doesn't get to the U.S. Supreme Court overnight, right? You go through the trial level, you have to go through appeals, and it goes and it goes. So this is a family that's not going to get closure. Right? Because they're hanging in the balance, waiting to hear what the final verdict is going to be, whether the trial verdict is going to stand or it's not. It's all of our tax dollars having to go towards the Attorney General's office to fund attorneys to keep fighting this, because again, we know it's going to end up in a higher court because it's already been declared unconstitutional by the Supreme Court. Like they said already in 2019 and 2020, you need to have a unanimous jury. These types of cases are not eligible for the death penalty. So he's hoping to create new law on the taxpayer's expense, not, okay, well, something came up in court that none of us ever really thought of. Let's, pursue it to its end. So his culture war is going to cost us money and cost us resources that can go towards helping survivors of sexual assault, or making sure that families who have lost their kids to violence get the help they need, or to prevent the next school shooting or the next, mass incident, because we're getting better resources for people. I mean,
I know. And you're 100% right. And something I failed to mention earlier is the Timely Justice Act was passed by Governor Rick Scott, and it required certain things to happen before a defendant was eligible for execution. And so the first is obviously the trial, right? Where until April 20th of this year, a unanimous jury had to both convict the defendant and recommend a death penalty be imposed. Then after that, the case goes through direct appeal to the Florida Supreme Court, and each of these processes takes years, and at any point the defendant could be remanded for a new trial or a new penalty phase or some other kind of relief. After direct appeal, the case goes through post-conviction, where a whole new set of lawyers are appointed to make sure the first set did a good job, and oftentimes that is not the case in this state. We have very few lawyers who are qualified and competent to do this work. After post-conviction, the case goes through what's called federal habeas. And again, each of these processes take years. And this is the Timely Justice Act signed by Republican Governor Rick Scott, current Florida senator. And then after federal habeas, the case goes through what's called clemency. And then the defendant is eligible for a warrant to be signed for his execution. But there is no limit to the amount of successive post-conviction claims his lifetime court-appointed counsel can file on his behalf. And so if people were interested in finality and closure for next of kin, we would be having these conversations that are hard and heartbreaking about the likelihood of execution and how many wounds are going to be reopened and ripped apart over and over and over again in this pursuit of execution that may never happen. And there's just one other thing I want to mention too, is that Florida is relatively new to unanimity as far as capital sentencing, which is why I think we feel like we're in a place to recede from it. The United States Supreme Court in 2016 said our whole capital sentencing scheme was unconstitutional in a case called Hurst v. Florida, because we had judicial sentencing instead of jury sentencing. And then after that, the Florida Supreme Court passed Hurst v. State in the Florida Supreme Court, saying unanimity was required in order for a death sentence to be returned. And so in 2017 is when we began requiring unanimous death verdicts for a death sentence to be imposed. Prior to that, it was just a simple majority. 7-5 was a death verdict or a death recommendation. And so part of me thinks that the prosecutors are still in that phase where they remember how easy it was to get death sentences pre-unanimity. But I have to think like states like Texas, right, that we all consider like a hang 'em state, right? Texas is certainly comfortable seeking, imposing, and enacting the death penalty, and they've had unanimity forever. And you don't hear their prosecutors complaining about it. And so that's the only thing I can think of is somehow these prosecutors have convinced themselves it's an overly burdensome task when everybody else has been doing it this way. I mean, that's the most common question I got from legislators this legislative session was, well, how many other states require unanimity? And I was like, all of them. All of them. Alabama is the only exception. Alabama requires 10 of 12 jurors in order for a death verdict to be returned. And anytime we're rivaling Alabama in criminal justice, I got to tell you, it's not a good thing. That's what I was jokingly saying. We should start a rumor that the Texas prosecutors are like, hey, Florida prosecutors, where you at? Like, if you can't convince 12 people, maybe the defendant shouldn't be sentenced to die.
That part, because you kind of can't take it back once it happens.
Right. And then I think that's what the like final to tie it all together part is that of the 30 exonerations that we've had in the modern era of the death penalty since 1976, almost all of them, so we're talking about people who were wrongfully convicted, almost all of those juries were non-unanimous recommendations for death. Mm-hmm. And so all of these problems are just baked into this cake, right? The kind of systemic racism and the roots of non-unanimous verdicts, the increased likelihood for wrongful convictions that also already runs rampant in Florida, the tremendous cost to the state of Florida and the taxpayers, and just the overwhelming and profound heartache that we are going to put these victims through. I mean, we are still retrying cases where defendants got relief pursuant to Hurst, right? So I am currently in a case that happened 19 years ago, and the next of kin have openly shared that this is just ripping open those wounds, which of course it is. And now we're at a point where the state's trying to apply the new law mid-trial. And I'm like, even if they get what they want and these defendants get sentenced to death, we will litigate this for the next 20 years.
Forever. Yeah. Oh, all right. Well, with all of that being said, Allison, how can people get in touch with you if they want to, seek you out for counsel representation or just to understand more around, the death penalty changes and how that's going to impact us here in Florida?
Sure. I am in private practice. I have been since I lost the race for state attorney. I was technically in private practice while running for state attorney. But as you know, running for office is a full-time job. Although I tried quite a few capital cases while running for state attorney, which of course who's supposed to be the Minister of Justice used against me. I tried 4 capital cases and helped select the crews jury while I was running for state attorney. But I'm with the law firm Ripley Wisenhunt in Pinellas County. My email is Allison, Allison, at rwlaw.org. Happy to talk death penalty. My firm does criminal law, as well as one of the partners at the firm, Dan, is really experienced in post-conviction work. And so people that have been wrongfully convicted and have already gone through the appellate process and are like, where do I turn now? Dan's a great resource, and we're happy to talk and hopefully help as many people as we can.
Awesome. So for everybody watching, there's going to be links in the comments. So that way you click right there, get a look at Allison's bio, learn about the firm, and be able to reach out that way. Allison, thank you so much for taking your time to educate us on the changes in death penalty and just, keep fighting the good fight. And thank you for all you do for the community.
Thank you.
All right. Take care, y'all. And we will see you next week. Bye.
Good night.